The next part of the process to acquire rights of way is appraisal review. Regulations require ODOT to review any appraisal when there's federal or state assistance in any part of project costs. Only appraisals must be reviewed by regulation. Value estimates utilizing the waiver valuation regulations, which is the value analysis report, are not mandated to a review. The appraisal review process is designed to ensure appraisal standards are met and compensation that will be offered to the owner complies with Ohio statutes and regulations, Ohio case law, ODOT procedures, federal regulations, and that the estimated compensation is fair and reasonable. The review options available to the review appraiser are recommend, also known as approved. That means the report meets all standards and is recommended as the basis for the establishment of the amount believed to be just compensation. Or the reviewer could accept the appraisal, which means the report meets all requirements but is not going to be recommended. It's not going to be used as a basis to make the offer. The last possibility is not accepted or rejected, and that means the report does not meet requirements and standards. The most desirable outcome of a review is for the review appraiser to determine the appraisal meets standards and therefore is recommended. If that doesn't happen, then ODOT will need to utilize another appraiser. The valuation process starts again, and months can potentially be lost from the real estate acquisition timeline. When an appraisal is recommended, the reviewer will complete Form RE22. This form documents the recommended compensation amount and the allocation of compensation and provides a detailed rationale for the appraiser's recommendation. The procedure for appraisal review is within the 4300 section of the ODOT Real Estate Manual. Next is the process to establish just compensation. The acronym for this is FMVE, which is Fair Market Value Estimate. Regulations require just compensation be established by an official of the acquiring agency before the initiation of negotiations with an owner. The process of establishing just compensation is described in the 4100 section, 43, and 5200 sections of the ODOT Real Estate Manual. Generally, the person establishing FMVE within a district office is the district real estate administrator. FMVE is established by the district real estate administrator signing the RE22 form for the value finding appraisal report or for the right-of-way appraisal report after these reports have been recommended by the review appraiser. When the value analysis report is used to estimate compensation, FMVE is established by the district real estate administrator signing the value analysis report after it's been submitted by the person who prepared the report. With FMVE established, ODOT can now make an offer of compensation to the owner of the property needed for the projects, and negotiations can be initiated. Next is the negotiation process. There can be no negotiations with an owner until the agency has established just compensation. The initial offer of compensation to any owner is regulated by Ohio Revised Code Section 163.04, requiring the offer to be made by certified mail or in person. ODOT's negotiation procedures are described in sections 5200 and 5300 of the ODOT Real Estate Manual. The negotiator is required to utilize ODOT's negotiator notes to document all owner contacts and conversations. The notes must be sufficient to document compliance to ODOT procedures and the regulations governing the acquisition process. The notes must be well written to the point that an average reader could understand the sequence of events, when meetings took place, who said what, and what regulations and procedures were applicable, and how the negotiator took steps to comply with those requirements. Eventually, negotiations will come to an end with the following results. A, the owner accepted the initial offer of FMVE. After that, a closing scheduled, funds will be dispersed to the owner, and the owner conveys the real estate needed for the project to ODOT. ODOT now has control of the right-of-way. ODOT has legal and perhaps physical possession. B, there were counteroffers, and ODOT agreed to settle at an amount higher than FMVE. This is further documented through the administrative settlement process. Finally, a closing is going to be scheduled, funds will be dispersed to the owners, and the owner will convey the real property needed for the project to ODOT. At that point, ODOT has control of the right-of-way, ODOT has legal and perhaps physical possession. C, there can be a negotiation impasse. The owner and ODOT cannot agree on price and terms. ODOT can then exercise its right of eminent domain. It'll make compensation available to the owner by depositing FMVE with the court, and at that point in time, ODOT obtains the right to use the property for the project. ODOT will coordinate an appropriation of the property needed for the project with the Ohio Attorney General's office. When the appropriation is of vacant land and ODOT deposits FMVE into the court, it has the right of possession. That is known as quick take. ODOT now has the right of physical possession and has control of the right-of-way on that parcel. ODOT will obtain title to the property at the end of the appropriation case. When the appropriation is of an occupied structure, ODOT will not have the right of possession until the judge issues an order of possession. Then ODOT will have the right of possession. ODOT will obtain title to the property at the end of the appropriation case. D, negotiations have been ongoing, but time is running out on the acquisition timeline. The right-of-way must be certified soon, but negotiations on a few parcels need more time. ODOT may need to appropriate these properties to obtain control of the right-of-way by the clear date, but this appropriation can be avoided if ODOT and the owner can agree voluntarily to the use of a right of entry contract. With the right of entry, the owner gives ODOT the right of physical possession, and the owner is paid some amount of money that is mutually agreed to. ODOT has control of the right-of-way. Acquisition is not over on these parcels, however. ODOT must obtain legal ownership, so negotiations are to continue until ODOT and the owner agree to price and terms, followed by a closing with funds being dispersed to the owner and title conveyed to ODOT, or ODOT and the owner will not be able to reach an agreement on price and terms, and ODOT will appropriate the property and obtain legal ownership of the property. The next part of the acquisition process is the relocation. This is relocation of people, personal property, businesses, and farms from the area needed for the highway project. It's mandated by federal and state regulations and is the process of assisting persons and businesses displaced by highway projects and assuring that replacement housing payments, moving reimbursements, and other benefits are offered in compliance to regulation and ODOT procedures. To ensure people are determined as displaced are moved or relocated from the project area in an expedient manner. The relocation process is coordinated with the acquisition process. In most instances, the two processes occur concurrently. Often, the relocation offer and acquisition offer are made at the same time. The procedures for relocation are section 6100 through 6600 of the ODOT Real Estate Manual. Displaced people, businesses, and personal property, which are known as relocation parcels, are to be cleared from the right-of-way by the date the certification of right-of-way letter is issued. Acquisition control of the right-of-way means acquisition of rights-of-way needed for the project are considered complete when ODOT has obtained adequate property rights that will allow ODOT or its agents and contractors to get onto the right-of-way needed for the construction and long-term maintenance of the transportation facility. The part real estate acquisition plays in obtaining control of rights-of-way is 1, reaching an agreement with price and terms, having a closing, dispersing funds to the owner, and the owner conveying the property rights needed for the project to ODOT. This gives ODOT physical possession and title to the property. 2, appropriating the property when agreement can't be reached, with ODOT obtaining the right of physical possession. 3, obtaining a right of entry on a few remaining parcels where more time is needed, giving ODOT the right of physical possession. And 4, moving people, personal property, businesses, and farms determined as displaced from the area needed for the project. And assuring compliance to federal and state laws and regulations and ODOT procedure, and that people are afforded all rights and benefits under these regulations. It's time for a knowledge check.